Welcome to Jackson Lewis's podcast, We Get Work. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every organization's mind: how will my business be impacted? Employers are increasingly faced with requests from employees to work abroad for a short period of time for a variety of reasons. However, these arrangements can present complex legal issues. On this episode of We Get Work, we discuss the immigration law implications of global remote work arrangements for U.S. companies. Today's hosts are Chris Anderson and Nadine Trin, principals, respectively, in the firm's Greenville and White Plains offices. Chris and Nadine, the question on everyone's mind today is, what accounts for employees' requests to work abroad? What could employers think about to minimize risk? And how will that impact my organization?
Thanks, Alicia. As Alicia said, my name is Chris Anderson. I'm a principal with the International Practice Group here at Jackson Lewis. And just a short blurb about what we do, because a lot of clients and prospective clients don't know it all the time, is that we work with mainly U.S. employers to send U.S. personnel around the world and deal with foreign employment issues around the world. But we work with employers in other countries as well. But we work on cross-border global employment problems for our clients. And it's just an amazing job to get to have. And today I have with me Nadine Trin, a great colleague. Welcome, Nadine.
Thank you, Chris. My name is Nadine, and we handle in our immigration practice both I-9 defense and compliance, as well as sponsorship of foreign talent for our U.S.-based clients. And I'm happy to be here with you all.
Great. Thanks so much for joining. And this is part one of a three-part series on global remote work. And we're going to define that for all three parts. We're going to do a part on immigration, which is why my friend and colleague Nadine is with us. And we're going to do a part on tax and benefits. And then we're going to do a part on employment. So stay tuned for those. But this is part one. And we're dealing with immigration first, for a special reason, because it's usually the big gating mechanism that needs to be addressed when you think about global remote work. And let me define what global remote work is for the purposes of these three sessions. It is, well, for our purposes, it is a U.S. person who, whether they're a non-immigrant in the U.S. on an H-1B or an L visa, or other visa type, or they're a U.S. national, but they've gone to their employer and they've said, I want to go overseas for a short-term period of time with a full intent to return for personal reasons. And the employer has no vested interest in them being in the other country. They're not sending them there. They're not assigning them, but it's just a personal request. And you may say that's a fairly tight definition, Chris, but this has come up weekly in my practice for the past 4+ years, really since COVID hit. And so this is a huge issue. The law is catching up with the reality. So it's a fun issue to think about. There's a lot of legal issues around it, chief of which are immigration, tax and benefits, and employment. So that's why we're here today. And we welcome all the listeners. Nadine, let me kick it to you, of course, to start us off with just give a 1,000-foot view of how you've seen these remote work issues from an immigration standpoint in your practice.
Thanks, Chris. I would say over time, and this was mostly prevalent under the pandemic, right? Post-pandemic, a lot of employers started seeing requests for remote work, right? And then all of a sudden, we started seeing maybe an uptick of individuals who happen to be in another country. In the context of an employee working from abroad, the employer may realize that the individual is spending more time abroad, has a personal reason such as a family emergency that requires them to stay longer than anticipated. Oftentimes, if the employee is on a non-immigrant visa, they do need to obtain a new visa to re-enter, sometimes in order to reactivate their work authorization inside the U.S. So with changes in processing, sometimes State Department schedules with the consulates and embassies abroad, they may actually experience longer processing times and delays in returning to the US. So if they are stuck abroad, they may have the ability to work remotely from their home country, if it is, in fact, their home country. Otherwise, the employer then has to anticipate the possibility that the individual may have to work from a third country. And if it is a third country, does the employer have a base there? Does the individual have the ability to work from that third country? There are a lot of questions that can come up when somebody's asking to work remotely from another country.
Right. And then the longer it goes on, the more material the other issues become, and that's the other sessions of this podcast series are dealing with when you trigger more tax risk, when you trigger benefit issues, when employment law becomes more material. So, and from an immigration standpoint, absolutely, it's material as well, because do you have that authorization, as you said, to be there and be working there? So Nadine, that's a great overview of how it comes up in your practice, and so thanks for that. But generally speaking, let's start with the U.S. side. What are the issues from a U.S. immigration standpoint, if any, that can arise when that U.S. The non-immigrant person in the U.S. leaves the U.S. for a period of time? Are there any issues with their non-immigrant visa if they're there with the intent to return? Are there any issues at all?
So, great question. Generally, no. If they leave U.S. soil, then it no longer becomes a U.S. immigration issue, right? They're here working pursuant to a work visa. That's what provides them with the non-immigrant visa status. The only future item to look at is whether they have the ability to return, right? So does the current petition cover them through a future period? And if they do return, is it in the same capacity, or does some sort of amendment need to be made ahead of their return to the U.S., depending on the current validity of their petition?
And would that be if their job duties change or something else, or where they land back in the U.S. if it's a different
Exactly.
state? Got it. Okay.
That's right. So any condition or term of their employment, the job title, the duties, the worksite location, this is much more emphasized for the H-1B visa program, because there's this underlying labor condition application that will specify the worksite locations. And if there's a change outside of that metropolitan statistical area, then an amendment needs to be filed ahead of the individual working from that worksite.
Got it. But just so listeners, if we boil it down to the classic case where there's not those changes, where someone just goes for a few weeks to a few months and comes back, no need for a change in that case, typically.
That's correct. On the U.S. immigration side, They're fine, because there's really no trigger. They leave U.S. soil. What triggers U.S. immigration is what status they are admitted in inside the U.S., and does it provide the ability for them to work?
Got it. Okay. And what about with a permanent resident? If they go and say they're there, you mentioned a minute ago that sometimes you're there for some purpose, and this happened a lot during COVID, where we saw people getting stuck, where the borders would shut down and you couldn't get back, and that was more with folks that are going to renew a visa. But say it's a U.S. permanent resident, and they just go home, and for whatever reason they need to extend their time past. Is there any certain point where they have to worry about that U.S. permanent resident status?
Actually, yes, and we did see this during COVID too. You might have a permanent resident who has a document that's expiring. Sometimes there is a delay in processing of the new replacement or renewal green card. On top of the fact that if they are a permanent resident, they have to maintain their U.S. permanent residency, right? They're filing U.S. tax returns. They are showing permanent ties to the United States. If they're leaving, this is different from somebody who's a U.S. citizen. They do need to maintain their ties, their permanent ties, in order to keep their green card status. So oftentimes it's a question of, are they spending more than 180 days? More than 6 months will then bring a presumption that they may be abandoning that permanent residency. So it's important for them to travel back frequently, and at least once every 6 months, even if they are working remotely from another country. Otherwise, they risk losing their permanent resident status.
Got it. And I'm going to go ahead and say right here, and this is absolutely not a hardline rule by any means, but just to put a little bit of parameters, even more on this, what we mean by short-term remote work. Most of my clients end up landing between what classic business trip of 2 weeks or so to a few months, with 6 months typically being the maximum. And not saying I recommend that everyone do a 6-month maximum, but that's there for a reason. If you listen to the tax episode that's coming up, there will be more on that. But generally, the 183 days, 6 months is what you want to not go past from a just general standpoint. And there's a lot of other factors to look at. Immigration, of course, being chief among those. So thanks for that, Nadine. And let's kind of pivot to potential immigration issues outside of the U.S. Just from your experience, what have you, I deal with this a lot, but I'd love to hear from you what you've come across, and just, what immigration issues can come up for that person outside the U.S. and for their U.S. employer, potentially, from your experience.
So in my experience, we've been seeing a lot of M&A activity. Companies are consolidating. A lot more of our clients have some sort of presence abroad. And how that helps in a situation where you have an employee who's looking to work from another country is, having another entity that's related to the U.S. employer does open up, some options for a future state, U.S. visa to return. But it also allows for that individual to be onboarded on the foreign payroll, right? There is a company abroad. We keep them within our global employee population. So that helps a lot. Now, if they are working abroad, some of the issues we see is, does that individual have a spouse and family? Does the spouse need to work in that other country, particularly if both were U.S. based, and then all of a sudden you have one requesting employment remotely from another country? Then you look to, the potential nationality, citizenship of that spouse, and what the work permit options are in that other country. So we do see a lot of trailing spouse options, if the spouse needs to work while this person is working, our employee is working remotely. And, a lot of them involve family issues, and in addition to just obtaining the work authorization in that third country or home country.
Right. So, and that's where you have, I'm glad you mentioned that, Nadine, because there are situations, and I've dealt with a lot of them, where the client does have that partner entity or, some affiliate entities there that they could assign the person to. And even if they're not proactively saying we need you there, they can have them there if there's a good reason for that. But what about in the absence of that? What risk have you seen come up? Let's just discuss those for a minute as well. That when the person's going somewhere with the company, the employer in the U.S. doesn't have any kind of entity or really any business in that country, is what I see every day come up over and over again with clients. And it raises a lot of worry for them of, is this okay? What are the risks from your experience? What are some of those risks from an immigration perspective then?
Yeah, of course. I mean, one option that we've seen practically is that, they will look at hiring them as a contractor in that third country, or that the employee's home country. And we've had that situation where, for example, recently we had an employer whose employees' H-1B visa maxed out at the 6-year mark. If any of the employers out here are listening, know that if you have an employee who's facing a 6-year limit and hasn't started any sort of employment-based green card process, then you're sort of out of luck with that extension of the employee's H-1B visa status. In this case, they had started the process, but kind of late, and not early enough to enable the employee to extend beyond the normal 6-year life cycle. And this individual went back to their home country. The employee, took the risk of employing them in the same role as a contractor. and while waiting out the green card process, which eventually came through, and there is a way to obtain a green card via what we know as consular processing, as opposed to adjusting status from H-1B to lawful permanent resident inside the U.S. It took a little bit longer. You're dealing with the consular post abroad, but eventually, the individual obtained their green card and returned to the U.S. and is in effect a permanent resident. But it's risky both, and I'm sure my colleague Bryn will speak to this on the employment side. If you decide to switch somebody from an employee to a contractor for the same role, even if in another country, but also you just don't know. There is some uncertainty on the immigration side as to when the immigrant visa or the permanent visa will actually be issued. That's also another unpredictable factor in all immigration processing. Ultimately, is just the timing, right? I mean, we're coming up against agency processing times. Sometimes there are shortages at the local consular posts. So it's all just a little bit of understanding how much risk can we take here in terms of employing this person abroad if it's in some sort of extended time period.
Right. And that's, the time period becomes so material for that, for sure. Really, in all these cases, once you know someone's going to be there for an indefinite amount of time, of course you have to pivot. And that's where having a policy that really lays that out, where once you're into uncharted territory in terms of risk, that you need to be thinking about, the contractor status, like you mentioned, Nadine, or getting an EOR involved to engage them. And that works if it's a national of that country, for sure. But if it's a non-national, if it's someone who's a U.S. citizen, for example, and they're going with their spouse somewhere for vacation, or their spouse gets deployed somewhere and they want to go with them, and you want to engage them as a consultant or through an EOR, an employer of record in that country, you're going to still have to figure out whether you can get sponsorship or some kind of authorization for them. I see the risk on the foreign country side come up often because the person who needs to have authorization in that country, what I see all the time is that they're there on visitor status, and which is typically fine for a business trip, right? But if someone's there for 3, 4 months, 5 months, and they're using just visitor status, whatever the country allows, then we can never say that allows them to work. And so there's some risk that our listeners need to be thinking about as they allow that, if they're going to allow that. But one great thing is that we've seen coming up, and I know we talked before, Nadine, and you said you've dealt with this as well, but digital nomad visas are becoming so much more popular now, and we're seeing the law catch up with reality there, where countries are saying we need to figure out some way to define this class of people who really, since COVID, but that's when it really has taken off, that are going to countries where they're not working there on the local economy, they're not getting payrolled there, they're not doing anything in that country work-wise, but they're working for their U.S. or other foreign employer. And so we're seeing these in lots and lots of countries now, and they do. The great news is, and tell me if you agree with this, Nadine, they do give set immigration authorization for a period of time, often 1 year, with even the ability to renew. And there are some issues that can come up on the employment side and on the tax and payroll side where it's not super clear all the time how much protection they give. We have ideas, but I think we haven't seen test cases yet to really test that out. And again, the law is catching up with the reality. But how have you seen digital nomad visas in your practice, if at all?
Yeah, and that's not as prevalent, I think, as it was right after COVID. And I think it came down to employers hitting the brakes a bit because whether it was an employment issue, immigration, tax, or even cybersecurity issue, we saw some hooks with cybersecurity in terms of remote employees not being able to log in from another third country because the employer wouldn't authorize it. So I think it was probably happening more, but in terms of, in practice, what I've been seeing, I think employers have been putting together more policies around this, more restrictions and more terms and conditions around allowing somebody to work for an extended period of time abroad. Where we have seen it is, again, with these employing organizations becoming larger around the world, having more offices and stations around the world, that if there is, I mentioned earlier, this future state of individuals needing to come back to the U.S. after this period of time abroad, they have, thought about, okay, what makes this person eligible to come back to the U.S.? And if they are, let's say, contemplating a U.S. L1 blanket visa program where you can pre-qualify related entities that are situated around the world, where you would employ somebody and then transfer them back to the United States after 1 year as an employee, this would not work in the scenario we've been discussing about somebody who's going to be employed as a contractor, right? A contractor status would not make this individual who's working for us for 1 year abroad eligible for an L1A intracompany transferee as a manager or executive, or L1B intracompany transferee visa as a specialized knowledge worker. So, oftentimes as the employer is trying to, map this out for the employee, it's really just, okay, can we do this for a period of time, short or long? If it's long, could we keep them abroad for 1 year? At least, right, as an employee, so that we can potentially bring them back to the United States where they initially started and where they may want to get their permanent residency, for example.
Yeah. I'm glad you raised that, because this, even though we narrowly define this, initial fact pattern of someone going for this short-term period and then coming back, employers need to be thinking about just how do we really want to engage people? One, do we want to allow this? And we can kind of close with some of these thoughts that if you want to allow it, then you need to have a policy for it. You need to really think through ahead of time what those parameters will be about who gets to even think about doing it, how long would they go, and that's where the tax and benefits and employment comes in as well. What kind of status will they have? Are they a national of that country? All those questions need to be part of that. But then the broader question is what you're talking about, Nadine, right at the end there, that you need to be thinking through, how do we ultimately want to engage people around the world? Do we want to have someone in this country? Do we envision that? And if we do, rather than having them just go remotely, because that's going to raise some other risks potentially if you're actually trying to do something there, then think about setting up your own entity, at least getting an EOR, an employer of record, to engage them for a bit of time. But to your point, they can't come back to the U.S. on visa status in the L visa status without that year abroad. So, but in the classic scenario where you're not thinking about that, if you're listening and saying, we're not thinking about, outbound operations, but you have people that are pressuring and they're saying, we want to go, we need to do that for family reasons, vacation, whatever it is. And you need that for talent reasons, talent acquisition, talent retention, you need to allow it on some level, or you feel pressure to allow it. Then having that policy in place, having a remote work agreement in place are all key things to have to set boundaries on it. And then ultimately to reach out for advice on the immigration side, but also all the other attendant risks as well. Nadine, any final thoughts from you?
No, the only final thought is, if it's a short-term period of time, it's really just important to look at the nature of the activity to be conducted abroad, right? There are parameters around business visits. This is a very common question we get. You can maybe conduct business, but you may not potentially be able to productively work. So just a reminder on distinguishing between a business visitor activity as opposed to a productive employment activity, which likely would require a work permit in that country.
Thanks, Nadine. Thanks so much for joining.
Thanks a lot, Chris. Appreciate everyone.
Thanks to our listeners.
Thank you for listening to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate a workforce that is engaged and stable. Please tune into our next program, where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on your streaming platform of choice, including Apple Podcasts and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com.